Good afternoon, friends. Today we will discuss the international framework for patent protection. So, in this international framework for patent protection, we will deal with the WIPO administrative treaties today exclusively. So, what uh, initiatives will lead to develop the one particular institution, that is World Intellectual Property Organization. So, what is the historical evolution before we deal with that WIPO? So, we should talk about the Paris Convention, Patent Cooperation Treaty, Patent Law Treaty, and the World Intellectual Property Organization finally. So, in the initially, where before the existence of any international convention, in generally, it is very difficult to obtain a protection for industrial property right. In those time, to resolve such issue, the government of the Empire of Austria-Hungary, so they invited some countries to participate in an exhibition, international exhibition, where they can display the inventions, which was in the year 1873 in Vienna. But this exhibition, foreign visitors were not willing to participate in the exhibition due to till then there is no proper legal protection. So because of that, the foreign visitors are not willing to join this exhibition. So in that year, same year, in 1873, there is a Congress of Vienna for Patent Reform. So in this Congress of Vienna for Patent Reforms, they elaborately discussed that we have an international understanding with regarding to the patent protection. So if that is there, then only the foreigners will have easily to exhibit their inventions. So later, a lot of discussions happen. In the 1883 discussion in Paris, it ended with a final approval of one convention, that is Paris Convention for the Protection of Industrial Property. So this Paris Convention for the Protection of Industrial Property, so this Paris Convention in 1883 established. So these entire provisions were divided into 4 categories. The first category, it talks about rules of substantive law. In the rules of substantive law, which basically guarantees the basic right, that is right to national treatment, in the first category. In the second category, it establishes another right of priority. In the third category, basically it allows the member countries to enact their own or local or domestic rules. And the fourth category, it talks about Paris Convention administrative framework. So these are the 4 categories we divided the Paris Convention. So national treatment. What do you mean the national treatment? So the national treatment is nothing but however the national should be treated, the same like you have to treat it with the foreigner also. That means in this perspective, what is national treatment means, if country A recognizes its national patents, then country A also recognized in the same line with the other country nationals also in their same country. So there is no discrimination with regarding to this foreigners and nationals. Here, those who are party to the Paris Convention, they are automatically, the country should not discriminate between foreigner nationals and nationals. If the country is not a part of the Paris Convention, what will happen? In that case, if that particular person may be domiciled in the country, or if that particular person have a real or effective industrial or commercial establishment in that such country, then also you cannot treat him as a foreigner. So there is a twin line difference between domicile and residency. In the domicile, basically we are all called it as residents in domiciles. The resident means it is for a temporary period. You will be settled somewhere else, then it is called residence. But if you are intention to have live there, if you have intention, for example, if you are getting a job in Delhi, okay, you are not purchasing any property there, and you said that after completion of my job I will be back to my hometown, then you are the resident of Delhi. But once you get the job in Delhi, you purchased the land in Delhi. That means what? You want to stay in Delhi after the job also. So that means that is your domicile. It may become your domicile. Okay, this is a long-term process, domicile. The resident is the temporary. So this national treatment rule is also applies both natural persons and legal entities. So we all know that what is natural person, the normal human being is a natural person. What is the legal entity? Sometimes the company also became a person, legal person. So in that way, some persons, legal, you can call it as a legal entities. So if a person, he want to get the domicile, it is easy. But what about with regarding to the legal entity? That means the second condition, that the legal entity has a real or effective industrial or commercial establishment in such country, then it can be called as that legal entity of. Also, you cannot discriminate. So you have to take national treatment rule. There is no doubt that state-owned enterprises of a member country created under the public law also considered as a national. So, if the legal entities have their actual headquarters in another member country, they may also be considered as a national of the headquarters country only. So this is the rule of if you are not having a real and effective industrial establishment in that country. So in the national treatment, there is a principle of reciprocity. That means reciprocity means practice of exchanging things. For example, India has a longer term of patent protection compared to the South Africa. In such case, India will not have the right to provide the South African nationals will enjoy same length within the India has. That means if you are providing that, for example, India has 10 years patent production, then South Africa has 5 years patent production, then with the reciprocity, if the South African nations files here, then you have to give only 5 years protection to them only. So that is the principle of reciprocity. But there is a exception with this national treatment rule is there. What the exception is, so municipal law is there. The Paris Convention under the third category of provisions, we are discussing this, that they can enact municipal laws. So in that case, what happened is the national law relating to the judicial and administrative procedures. At the same time, the jurisdiction and the requirement of representation. So these two issues can be reserved. So that means, so those procedures nature which impose special conditions on foreigners for the purpose of judicial and administrative procedure, it is validly invoked against the foreigners. So that means while if you treating the if you treating the administrative purposes differently with the nationals to the foreigners, that is valid in the case of national treatment. So the application of the national treatment is both nationals and non-national countries, member countries and non-member countries also. If it is member country, no, don't worry. If it is not a member country, then you have domicile or their industrial or commercial establishment must be there. A mere letterbox or the renting of a small office with no real activity is not sufficient. We are seeing so many cell companies are establishing there. So such type of mere letterbox, it cannot be sufficient for asking a national treatment. The second one is right to privacy. Priority, right of priority. What the right of priority means, at the time of 1883, there is no concept of single application throughout the world. So different applications may be filed to want protection. So in that case, what happens is, for example, if the person A is filing an application in India for the protection, so he will get the protection in India, but he also wants protection in US. Now, again, he go to US, he file an application, then he will also get protection there, but the time is different. So the right of priority, it bends the time difference. For example, according to this right of priority principle, if the person initially registered in India, later subsequent application put in the America within the prescribed time, okay, in that case what happens is the date of first application is considered as registration in the second country also. That means in US also, the effective date of back date, the first application made in India, that date is considered. So right of priority means if you file a regular application for an industrial property right in one of the member countries, on the basis of that you may within a specified period of time apply for the protection in all other member countries also. So these later applications will then be regarded as the same day as the earliest application. So this right of priority, it offers a great practical advantage to you. As an applicant desiring protection in several countries, you are not required to be protected. So in the length of the priority period, with regarding to the different industrial properties. So the patent generally having 12 months. That means within the 12 months, if any patent holder filed in India with regarding to application, within the 12 months, if he filed the same application, subsequent application in any member state of the Paris Convention, then automatically it gives the first date from the recognition in the second state also. With regarding to industrial design and trademark, it is 6 months. The right of priority can be based only on the first application for the same industrial property right which may have been filed in a member country. So that means whatever claims you are filing in the initial application, so in the final also you have to get the protection of that only. That means this provision was added because subsequent additions in the patents will lead to the backdate retrospective effect of recognition. So a second, if there is not possible to follow a first application by second, so possibly improve application and then use that second application on the basis of priority. So the reason is one cannot permit an endless chain of successive claims of priority for the same subject. So with regarding to this right of priority, the time is necessary. At the same time, the initial application is necessary. If in the same application was filed within the specified period in another member country, then you can get the protection from the backdate. That is retrospective. Next one is provisions concerning parties. Independence of parties. So the convention allows the member countries to establish their own rules and procedures for granting and enforcing of intellectual property rights, such as Patent Act, Trademark Act, like that. So, but at the same time, it does not harmonize the substance of the national laws, but provide a framework for international cooperation. So this must be necessary. If there is no cooperation with the international framework, then that law must be you can call it as a nullified also. So they want to make some universal provisions, you have to follow that. Along with that, you cannot harmonize the international framework, you can access the domestic legislations. The second provision with concerning parties is importation. So the importation by the patentee into the country where the patent has been granted. So the articles covered by the patent and the manufactured in any of the contents of the union, that entire the member countries union, will not entail forfeiture of the patent. That means if a member country is granted, now that member country can take or manufacture in any other countries of the Paris Convention Union, then the property will not be forfeited, because that will give the recognition of all the member countries of the Paris Convention. So, according to Paris Convention, patentees who are entitled to benefit from the Paris Convention and who having a patent in one of the countries of the Paris Union import this country goods. So in such case, the patent granted in the country of importation may not be forfeited in a sanction for such importation. So this is one good issue with regarding to this Paris Convention. Next one is compulsory license. So these compulsory licenses are intended to prevent the abuses which might result from the exclusive rights conferred by the patent for the invention. So when a law of member of the state follows such a compulsory license, so they gave some conditions to the patent owner to must satisfy. So first condition is authorization of a compulsory license must be considered on its individual merits. This means the applicants for compulsory license must be considered on a case-to-case basis. And the second one, a compulsory license can only be granted if the proposed compulsory license had made efforts to obtain authorization from the right holders on reasonable commercial terms with a reasonable period of time also. And the third one is the scope and duration of a compulsory license must be limited to the purposes which he was authorized. And fourth one, a compulsory license must not be non-exclusive. The fifth one, a compulsory license may not be assigned without that part of the enterprise or goodwill which produces the product under that license. That means if you are not assigned the license, if you are not assigned a particular uh, enterprise or particular thing that produces the product. And the next one, a compulsory license must be authorized predominantly for the supply of domestic market of the members other than the grants the license. Next one, the compulsory license must be liable to be terminated, subjected to adequate protection of the legitimate interest of the compulsory license. The patent owner must be paid adequate remuneration in the circumstances of each case, talking to account of economic value of the allowed use also. Next, the legal validity of any decision relating to the grant of a compulsory license must be subjected to judicial review also. And between two patents belonging to different owners, so that Sorry, due to signal problem.
Okay, sir.
Yes, yes. So the patent corporation entity, this patent corporation entity was established in 1970, but it came into force on 1978. So what are the objective of this patent corporation entity? So the objective of the patent corporation entity is that it rationalizing the application procedure. That means there is a multiplicity of application you have to submit, even though you are having national treatment, the priority, even though you have to do multiplicity, multiple applications you have to file. So this multiple application procedure was rationalized. It gave some powers to the patent officers. It to protect the interest of the users, this patent cooperation treaty came into force. So the patent cooperation treaty is an agreement for international cooperation in the field of patents. So most significant advancement in international cooperation in this field since the adoption of the Paris Convention. So largely a treaty for rationalizing and cooperation with regard to the filing, searching, and examination of patent applications and the dissemination of the technical information contained therein. So, the task of the responsibility for granting patents remains exclusively in the hands of the patent office. The principal objective of the patent cooperation treaty is to improve on the previously established means of applying in several countries for the patent protection. So this acts both in the interest of the user of the patent system and the offices which have responsibility.
Sir, PowerPoint not visible.
PowerPoint is not visible.
PowerPoint, PowerPoint.
Wait, okay. So the principal object of this patent cooperation treaty
Okay, sir.
is to improve the previously established means of application in several countries. This uh, principle of cooperation treaty through this applying means acted in both the interest of the users of the patent system and the offices which have responsibility for administering it also. So to achieve the patent cooperation treaty objectives, what they done, the PCT, patent cooperation treaty. First, it establishes an international system which enables filing with a single patent office of a single application in a one language. So this was first they done. The second one is it provides for the formal examination of the international application by a single patent office. Third one, subjected to the international application to an international search. So this in deciding whether the invention is patentable or not, the each application is subjected to the international search. The fourth one is it provides a centralized international publication also with regarding to international applications. The last one, it provides an option for an international preliminary examination of an international application. So these are the uh, developments which was done by the Patent Cooperation Treaty to achieve its objectives. What are the functions of Patent Cooperation Treaty? So the functions of the Patent Cooperation Treaty, first, filling an international application. Any national or resident of this Patent Cooperation Treaty can file international application. So that means the member state can file an application within the national office. So the national office will act as a receiving office of the application. Along with the international bureau can also act as a receiving office after this national office will send this application to there. So an international application has the effect from the international filing date. The Patent Cooperation Treaty prescribed certain standards for the international application. So an application which is prepared in accordance with these standards only will be considered as the international application. Along with that, the applicant has to pay a certain amount of fee. The fee is paid in a single set. That means initially, if you are taking application, if you are file application in India, you have to pay amount in India. Later, if you want to apply an application in America, you have to pay the fees in America also. But according to this PCT, you have to pay only once. Single set of fee is incurred for the preparation and filing of the international application, and that also payable in one currency at one office, that is one receiving office you can file. The fee is basically divided into three main elements. Number one is transmittal fees, second one is search fees, and the third one is international fee. So transmittal fee. So the transmittal fee is to cover the work of the receiving officer. So when you put the application to the patent office, that patent office acts as a receiving office. So to cover the work of the receiving officer, they are charged as a fee, one part of the fee that is called as the transmittal fee. Another second part is search fee. Once you make an application with regarding to seeking the protection, then that application, the nodal officer of the patent office will send that application to the international searching authority. So the international searching authority, what they've done is they will search if there is previously any patent available on that particular issue. So for that, they charge something in the fee part that is called as search free. Third one is the international fee. So the international fee, it covers the work of the international bureau, that is searching, publication. This all comes under that. So an applicant who is a natural person and who is a national of a or resident in a state whose per capita national income is below a certain level. So based on the income figures used by the United Nations, it determines the assessment for the contributions with regarding to that what the PCT fees. So basically this fees is dependent on the per capita income of the per capita national income of the where you are filing application. The second one is the second function is international search. As we already told that international searching authority is there. So every international application is subjected to the international search. This a high quality search of the patent documents and other technical literature happens. So this high quality international search is prescribed through the documentation. So you have a lot of documents you have to search. For that, you require staff. So specialized staff, special skilled staff. Even the searching methods of different methods also adopted by the International Searching Authority. So this the result of International Search Authority, the result given in a international search report. This international search report, which is generally available to the applicant after the 4th or 5th month of his application. So the International Searching Authority sends this information, international search report, to the applicant and the International Bureau. So this International Bureau includes the search report in the international publication and send it to the designated offices. This is the procedure in international search. The third function, international publication. Generally, the publication serves two main purposes. Number one is it discloses the information with regarding to invention to the public. That is technical advance made by the invention such that. The second, it sets out the scope of the protection which may be ultimately he obtained. So the International Bureau publishes the search order, search report, which contains a front page sitting out bibliographic data. So the data must be such as International Patent Classification Symbol. So there is a symbol, International Patent Classification Symbol. After the classification symbol only, you have to disclose publication. You have to publish. So this international publication, it only you can get after the 18-month period of international application made. This publication, this international publication, which was announced through the publication of Patent Cooperation Treaty Gazette. So this Patent Cooperation Treaty Gazette, which lists the published international application in the form of entries reproducing data So each issue of this publication gazette also contain the classification index that will allow the selection of the published international application by the technical fields. So these publications, that is the pamphlet and the PCT gadget, these are distributed free of charge by the Alex International Bureau on a systematic basis of all patent cooperation treaty contracting states. They are now also available in the DVD format to the public. They are supplied on request against the payment of some fee. So, what are the advantages of this patent cooperation treaty? The advantages of this patent cooperation treaty is, so the advantages, basically three advantages with given: advantage with respect to patent office, advantage with respect to applicant, advantages with respect to national economy and industry. What is the what are the advantages for the patent office? See, more and more patent offices are considered how to employ their available manpower to the greatest advantage. This is true because the number of patent applications which they must handle. So, for in such a country, in the process of development, the number will surely rise. It increases with the country's industrial activity. So, patent offices are being required to fulfill the expanding role of providing technical advisory. So, this responsibility, because of available patent documentation and the technically trained staff, so the skilled manpower required role increase it to suggest local interest, local industry also. At the same time, it advising the use of technology to the particular local sector, those people who are there. So due to this, the patent office advantage. The second advantage is for applicant. What the advantage will get the applicant? If the applicant filed the application within one country, he will get the protection in the foreign countries also. And he has also having more time to make up your mind as to those foreign countries in which you wish to seek protection. At the same time, you have to spend less much money in the stage prior to the granted patent. At the same time, if you do not use the international procedure offered by the patent cooperation treaty, you must start preparation for filing abroad 3 to 6 months before the expiration of the period, priority period. We are having national priority, right to priority, na, according to the Paris Convention. If you are not use this PCT, then what will happen? You have to file within the limited period in the foreign countries. So you need to file one application under PCT. At the same time, because of one application, it need not required to be submitted in many languages. So translation you could avoid it. And the third advantage is advantages to the national economy and industry. So the patent granted on the basis of international application, which will usually provide a sound basis for investment and a transfer of technologies. The technological process is an essential factor of national economic development. So the patent cooperation treaty system, it greatly facilitates the obtaining of patent protection on an international level. And since the patent granted through the patent cooperation treaty route have been subjected to high quality international searches, and usually the international preliminary examination, more and more applicants are seeking protection on international level through this patent cooperation treaty. Next one is the more licensed technology, the foreign investments will be stimulated. The further important advantage of the patent cooperation treaty for especially the developing countries, its its information will affected the national economy. That means it can be very difficult to obtain complete picture of the entire patent document published in many countries, in many languages, most recent state of it. Since many important investments are subjected to the patent cooperation treaty application, developing countries have through the international publication of these applications early and easier access to modern technological information. So the usage of already established, the national countries want to develop their technological information. The next one is patent law treaty. So patent law treaty applies to both national and regional applications, so that the applications for patent for invention, applications for patent for addition, and divisional applications for patent for invention are for the protection of patents of addition. So the patent law treaty applies to all patents for invention and to patent of addition which have been granted by the office of the contracting party or by in another office on behalf of the contracting party. So the aim of this patent law treaty, why it was established? So the aim is to harmonize and streamline the formal procedures for national and regional patent applications. Simplifies and minimizes patent application requirements to obtain a filing state. And this PLT limits the formal requirements that contracting parties may impose. And this patent law treaty, it eases the representation requirements for formal matters. So the patent law treaty provides a basis for the electronic filing of applications. It provides relief to the uh, time limits that may be imposed by the intellectual property offices for a contracting party and a reinstatement of rights where an application the owner has failed to comply with a time limit and that failure has direct consequence of using the loss of rights. Finally, it provides for correction or addition of priority claims and restoration of priority rights. So, what is the difference between patent cooperation treaty and patent law treaty? So, what is the similarities and what is the difference it has? So, the PCT and PLT are patent cooperation treaty and patent law treaty. The patent cooperation treaty and patent law treaty, these are complementary treaties that work together to improve the efficiency and effectiveness of the patent application process. So while the sharing common goals, they have a distinct focuses. First, the patent cooperation treaty, it is streamlining the international filing process. But with regarding to patent law treaty, it harmonizing the patent formalities. The patent cooperation treaty, the scope is it covers the entire patent application process from filing to grant. But the patent law treaty, it focuses on a specific formal requirements and procedures only. The key benefits with regarding to this patent cooperation treaty was cost saving, time saving, and increased the success rate in the global protection. But in the patent law treaty, the focus, the key benefits are simplified formalities, reduced administrative burden, the predictable procedures are there. It also lowers cost. So, what is the implementation of patent cooperation? For the implementation of the patent cooperation treaty, it requires adherence to patent cooperation regulations and procedures. But with regarding to patent law treaty, with regarding to provisions and national regulations, these are the basically the PCT, patent cooperation treaty talks about streamlining the application process. Patent law treaty, it harmonizing the patent formalities. This is the main difference. Next, WIPO, World Intellectual Property Organization. So, as we see the Paris Convention, the growth of the legal framework development in 1883. The history of WIPO plays some crucial role. So during the 19th century, so before the existence of international convention with regard to the Paris Convention, it was very difficult to obtain the protection for industrial property rights because till then various domestic laws are there. To compile all these domestic laws, it is very difficult to get the protection. So the patent application had to made roughly at the same time in countries in order to ensure that the publication in one country doesn't destroy novelty of the invention of the other country. So these practical problems created strong desire to overcome such difficulties. So many in the exhibition which was conducted by the government of Hungary, their foreigner visitors are not willing. Why they are not willing? Because inadequate legal protection was there. So this exhibition develops two developments. One is they secured temporary protection at the time. The foreigners secured temporary protection in the exhibition of their inventions. Secondly, the discussion of the Congress of Vienna patent reform in 1873, because a number of principles on which the effective and useful patent system should be based was discussed, and also this became discussion to adopt that Paris Convention in 1878. So the ongoing discussions will continue till 1960s. That time, 1967, the official convention with regarding to establishment of World Intellectual Property Organization was signed in the Stockholm Conference in 1967, and it came into force in 1970. So before that, in 1883 and 86, go back to 1883 and 86, so the Paris Convention has separate um, establishment with regarding to their secretariat is there, which deals with exclusively with the industrial property. And the Berne Convention also develops a secretariat which will oversee the copyright related matters. So these two secretariats in 1893 united these two secretariats. So after this united, the name was given as BIPRI, BIPRI. This is a French acronym. Basically, it was established in Bern in 1893, but the headquarters shifted to Geneva when it was supposed to be established as a WIPO. So, in 1967, diplomatic conference on Stockholm, the WIPO was established. So, the BIPRI acronym is a French acronym. The BIPRI full form is United International Bureau for the Protection of Intellectual Property. So, WIPRO's predecessor this. At the same time, so the WIPRO was established. There is a difference between UN in UN specialized agencies under UN and which are not comes under the specialized agency. So WIPO is not a UN specialized agency. If what becomes if a specialized agency means if a specialized agency, what the members of specialized agency is nothing but those who are the members of the United Nations, it will become the members of that specialized agency. Until unless you you on the face of it you said that I don't want to become the member unless it will be the become the member of it. So in this each these specialized agencies, why it is too much important is It has its own constitution. It has its own governing body. It has its own executive activities and income and own budget, own staff, and also they have conduct own programs and activities. So there is an agreement between United Nations and World Intellectual Property Organization. The agreement recognizes the World Intellectual Property Organization is the subject to the competence of the United Nations and its organization because it is responsible for taking appropriate action in accordance with the basic interest, basic instrument, treaty, and agreements administered by promoting all creative intellectual activities. So, the World Intellectual Property Organization declares that members shall be open to any state. So, to become a member, a state must deposit an instrument of ratification or accession with the Director General of World Intellectual Property Organization at Geneva. So, what is the main mission of this WIPO? So the main mission of this WIPO is through international cooperation. So it promotes the creation, dissemination, use, and protection of works of the human mind for the economic, cultural, and social progress of all mankind. So this is the mission of WIPO. An outstanding example of the expansion of WIPO is the growth of its registration activities. The increase in the use of international treaties, which creates the facility of a single procedure to apply for patents, the registered trademarks and industrial designs, which is valid in all to all state members of those treaties. So the Patent Cooperation Treaty, the Madrid Agreement, the Protocol concerning the intellectual trademarks, the Hague Agreement concerning the international deposit industrial designs, these are all raise the increased volume of registration activities. But with the application of Patent Cooperation Treaty, in particular, accounting for a large share of such application. So, to strengthen this, WIPO's work is a new international treaty came into existence. So, the WIPO also established the Patent Law Treaty in the year 2000. The purpose is to streamline the application procedures and to reduce the cost of obtaining simultaneous patent protections in several countries. Next, the administration of World Intellectual Property Office. So the convention establishing World Intellectual Property Office, it provides four different organs, that is the General Assembly, Conference, Coordination Committee, and Secretary. The two main bodies are General Assembly and Secretariat. So, General Assembly, what are the functions of the General Assembly? The General Assembly is the supreme organ of World Intellectual Property Organization. So it appoints the Director General upon nomination by the Coordination Committee. At the same time, it the function is It reviews and approves the reports and activities of coordination committee, and it adopts the financial regulations of WIPO, and it approves the measures proposed by the Director General concerning the administration of international agreements. At the same time, it also determines which state is not a member and which is a member. So these are all functions were under the control of General Assembly. The other one is Secretariat. So basically, this Secretariat is also called as International Bureau of WIPO. What the power of this is, Secretariat is they appoint, they headed by the Director General, and they also employ regular staff and the professional staff. So this employability will be based on the principle of equitable geographical distribution, and other staff are from a wide range of countries of all regions of the world. The conference, so the conference is composed of all the member states of WIPO. In practice, the conference never meets separately from the General Assembly. It meets during the same period and in the same room as the General Assembly, and the only ostensible difference is the proceedings, the presiding officer in the proceedings differs. So, what is the development agenda of WIPO? So, the development agenda of World Intellectual Property Organization, it was adopted in October 2007 by the General Assembly. They're adopting 45 recommendations to enhance the organization's activities. So, for our convenience, we decided to describe that agenda into 6 clusters. So, first cluster talks about technical assistant and capacity building, and the second is it talks about norm setting, flexibilities, public policy, public policy, and the public domain. It also talks about technology transfer through the information and communication technology, and it is the access to the knowledge also. So the institutional matters, including mandate and governance, is also one of the agenda. These are the 6 clusters which divided the 45 recommendations. And the next one is the enforcement of World Intellectual Property Organization in the IPR enforcement. So, as you know, the World Intellectual Property Organization plays a vital role in supporting the member states in the enforcement of the IP rights. The organization provides a technical assistance, legal advice, and resources to help countries strengthen their intellectual property enforcement mechanism. So, number one is technical assistance. So, this World Intellectual Property Organization, it assists countries in, especially in the developing countries, for the implementing of the IP enforcement strategies. So, this also covers all the holistic view over the enforcement, including providing trainings and investigating techniques, how to collect evidence, what is the legal procedure involved. So these are all covered, given by the technical support by the World Intellectual Property Organization to the member countries, especially the developing countries. The second one is international cooperation. So this World Intellectual Property Organization, it facilitates international cooperation. So to address cross-border intellectual property infringement. So due to this globalization era, LPG, so borderless the borderless crimes are happening. So this borderless crimes, if you want that, you want to mitigate that borderless crime, you want international cooperation. So for that, to address the cross-border intellectual property infringement, international cooperation is necessary. So this including coordinated investigations, are sharing intelligence with their intelligence office policies, and providing mutual assistance, enabling countries to work together to protect the intellectual property rights. The third assistance is capacity building. So, to enhance the knowledge and to enhance the skills of the officials who are effectively detect or investigate or prosecute the intellectual property infringement cases. So, for that, the WIPO is giving training programs. The other assistance is online resources. So, in the online resources, what they have done is they have to maintain a database with regarding to enforcement of intellectual property. So these resources providers, for example, the best practices, access to best practices, or case studies, the relevant legal framework, these are all given by the WIPO to the developing countries for the strengthening of IP enforcement, intellectual property enforcement. At the same time, it has also having dispute resolution mechanism also have. What the intellectual property office offers a comprehensive range of dispute resolution service to resolve the IP dispute, minimizing the potential of cost and protracted litigation. They adopted the method of this arbitration, mediation, and expert determination. So in the arbitration, yesterday we talked this arbitration, mediation, and expert determination. What arbitration? A formal process for resolving intellectual property dispute outside the court system. In the arbitration process, a arbitrator, according to the arbitration clause of the application, if you are saying any
expert person as the arbitrator, then he will be the arbitrator. Otherwise, the court will be appointed one person to the arbitrator. So why the people are choosing arbitration? It is basically faster service and cost-effective service to settle the dispute. The same line with the mediation. The mediation where one neutral third party with the conciliation of both parties to reach a mutual agreement or mutual settlement agreement. So a mediator was appointed. So instead of arbitration, why people going to mediation means they want to keep the relationship safe, healthy, and they want to solve privately the dispute. So in that case, they want to go with mediation. Next, last one is expert determination. This is a process where a neutral expert decides on a specific either technological or legal issues at this intellectual property disputes. The expert determination it provides a cost effective and it is efficient way to resolve technical or factual disagreements of the intellectual property cases. And the old intellectual properties approaches to traditional knowledge and genetic resources. So this old intellectual property it promotes, it protects the traditional knowledge and the genetic resources because it recognizes the importance of indigenous communities at the global level. So to protect the traditional knowledge and genetic resources, first they done is protecting traditional knowledge. So they are recognized and adopted a international framework to safeguard the traditional knowledge by promoting awareness about the importance of traditional knowledge and the use and the encourages the use of the traditional knowledge also. Second one is access and benefit sharing. So WIPO promotes the establishment mechanism of that access and benefit sharing with relating to genetic resources because the indigenous communities and local communities they are they want benefit from the commercial use of genetic resources. So this will ensure equitable access in the research and the development also to foster the sustainable utilization of the resources. The third one with regard to capacity building, WIPO provides a capacity building programs how to protect indigenous the traditional knowledge from the indigenous communities and local communities, especially the genetic resources protection also. So they effectively manage the intellectual property rights, ensuring fair and equitable access to the knowledge and resources, and also international cooperation. Yes, to want to protect the traditional knowledge and genetic resources, you must collaborate with the various indigenous communities, governments, and stakeholders to develop an effective framework for protecting and utilizing the valuable resources also. So these WIPO, World Intellectual Property Offices, they cooperate with the member state in these three issues with regarding to policy development, with regarding to capacity building, with regarding to enforcement support, with regarding to dispute resolution. So the organization closely works with the member states, including fostering dialogue, exchanging information, provide technical assistance to support the member states in the development and implementation of the effective intellectual property system. So, what is the contribution of WIPO to the international intellectual property system? So, the contribution is international cooperation to build a multiple platforms taking to the same to protect the traditional knowledge, to protect the genetic resources. So, the international cooperation they done. Second one, global intellectual property standards. They increased the standards. They rationalized the standards what they want to use. And third one is research and analysis also with regarding to policymakers and stakeholders. It helps in the relevant and responsive to the evolving needs of the intellectual property. At the same time, it helps in the sharing the knowledge also. So, what are the challenges and future directions for World Intellectual Property Organization? So, the challenges, the initial challenge is regarding the emerging technology. The second one is globalization, digitalization. Third one is access to intellectual property protection. Due to this, medium and small enterprises in developing countries, they want equitable and affordable protection. And at the same time, it has to another challenge, balancing between innovation and protection. So these are the four challenges where the intellectual property, the World Intellectual Property Organization has to focus on that. So with this, I'm concluding today's the intellectual property international protection on the intellectual property rights, especially the WIPO administrative treaties. That is from the Paris Convention to Patent Cooperation Treaty, Patent Cooperation Treaty to Patent Law Treaty, Patent Law Treaty to this World Intellectual Property Organization establishment, its functions, its dispute redressal mechanism are discussed. So tomorrow we will discuss with regarding to the World Trade Organization and TRIPS agreement, the trade related intellectual aspects of trade related intellectual property rights. So these two will be discussed in tomorrow's class. So if you have any doubt, could you explain compulsory license, how IPR helps in economic growth of the country? So in the first class only, we are discussing how this socio-economic development of intellectual property rights. So if the intellectual property, how it helps in the economy of the country means it will foster the technology. Once second, for example, if you take uh, industrialization, if you are making any product patents or process patents, these product patent and process patents will the country has exclusive utilization of that product or that process. That country will be benefited. For example, if you take the most of the car models and designs from the European countries, so they are now imposing whatever they want taxes. So if that inventions are done in India also, the Indian also will economically benefited. And with regarding to the compulsory license, in the patent cooperation treaty, what the patent cooperation treaty talks about the compulsory license. Huh? The patent cooperation, yes. In the Paris Convention, we are divided the provisions into four parts. So one in the third category with regarding to the developing your own country's legislations. In there, we are discussing about compulsory license. So why this compulsory license is necessary? So according to the Article 5A of this uh, Paris Convention, it exclusively talks that four feature of the product, four feature of the product. So we are before that we are discussing about importation. In the importation, what we have done is the one is a patentee who is in the country where the patent has been granted. In that case, the and if he can generate the patent in anywhere of that union. So that is, if you got the compulsory license in any particular member of that union, then you can then you can generate that or manufacture or use that patent in other countries also. Compulsory licenses, nothing was there. Okay. So this is the compulsory license. Just we are discussing about provisions concerning parties. In the provisions concerning parties, there is the independence of parties. They can enact the domestic legislations. Along with that, there is a importation clause. In the importation, we are discussing the compulsory license. If you are having a compulsory license, if you take in in any of the member countries, then all the remaining countries are bound to accept that there is no fee for future happens. So that is the that one. At the same time, we are also discussing the what conditions must be there to fulfill the compulsory license. So these compulsory license, these conditions only will allow you to take the compulsory license. The first one is authorization of the compulsory license must be considered on its individual merits. That means license must be considered the case by case basis only. Number one. Number two, the compulsory license can only be granted if the proposed compulsory license has made efforts to obtain authorization from the right holder of within the reasonable commercial terms. That means if he has not been successful within a reasonable period of time, that the compulsory license may be cancelled. So the scope and duration of the compulsory license must be limited. You cannot, it is not an exclusive limit and it is not a lifelong limit. It must be some time duration must be there. And the compulsory license may be assigned without the part of if you are giving a license to other, in that you are assigned on compulsory license, then in that case the assignment you cannot assign the product which is not produces. That means you cannot assign the work, the invention which you cannot later that person cannot produce a product. If the essential element must be assigned. So at the same time, the compulsory license must be authorized predominantly for the supply of the domestic market of the members that grants the license. And the compulsory license must be liable to be terminated if any provisions are violated. this compulsory license will be terminated. At the same time, the owner in this, the owner of the patent should be paid adequate remuneration in the taking the account of the economic value of the what they allowed to use. At the same time, this the legal validity, this compulsory license is subject to the judicial review. And in the case of dependency between two patents are there. So in that case, if different authors, different owners belongs to two patents, if both patents are dependency, then the latter patent cannot be exploited without infringing the earlier patent. So these are the conditions to fulfill the compulsory licensing the case. Okay, I have a small work. Tomorrow I will explain this compulsory license with a case law. Okay. Later, no international patent filing. See, till now we are discussing that patent of applications with regarding to that WIPO, till WIPO, we are discussing that there is a multiple applications are there. Before Paris Convention, you have to go through, in the Paris Convention also they said that you have to apply in the domestic at the same time as well as international. So in that case, you have to fill application both places and you have to pay the fee both governments. So in that case, what happen is the patent holder, the person who want to apply patent will be make a more burden. So what happened is in initial days, the patent cooperation treaty, what they done is they said, no, no, one place is enough for applying the patent. Later patent law treaty came, it will be some harmonize the application procedure also. So till we are discussing the patent harmonizing process, that means we are making one application here only. So that means there is, yeah, that is the point where there is a lack of unification between global unified law with regarding to the recognition of one single application. So till now we are discussing that the development of World Intellectual Property Organization. So tomorrow, after discussing the compulsory license process, we will move to the World Trade Organization and TRIPS agreement. Thank you.